Good morning and welcome to Defense Diaries. I completely overslept today because yesterday was a really long day and I just set this live. I don't believe, have missed a thing. So I'm going to pull this up just so we have it up. Yeah, I literally woke up at 8:57. I slept like an angel, though. I slept like an angel. Oh, hi. Oh, did you just wake up too?
No, I've been here.
Oh, all right. So let me see.
Cover me for reads, Cam.
Oh, you want to?
Get on the left again. Get on the left side.
All right.
Look at me.
So I'm going to put up 10. I like 10. Do you guys think there's a better one than 10? Oh, it's starting in 30 minutes? Ah. Ah.
Wait, is this live?
Yeah, we're live. Well, there's OnlyFan. Well, we can hang for 30 minutes with OnlyFan.
Shower. I'm watching Tony's season of Survivor. It's crazy.
Tony who?
Tony, the guy who swore on his kid and lied the whole time.
Oh, yeah. Yeah. So did you guys watch last night's live? I think you should. It's pretty good. It's pretty good. All right, I'm gonna let some people gather in. I'm gonna go get a drink, and we will watch this Care and Read thing as soon as it starts. I'll be back. All right, I've got my coffee made. So yeah, I wouldn't have started this until 9:20 if I would have known they were starting at 9:30. Thought they were starting at 9 my time, 10 their time. All right, I am not sure exactly what motions they're going. I'm assuming that they're going to go through what Brennan filed yesterday. So while we're waiting this last 10 minutes, we'll guess, and we'll throw these up. Let's see. We'll go through these things. Um, I'm guessing this is going to be one of them. This is the Commonwealth's notice of intention to introduce extrajudicial statements of the defendant. So this is Brennan seeking to put in all the interview stuff. Huh? I don't know if he did or he didn't, but this was just filed yesterday. So this says now comes the Commonwealth in the above caption matter and indicates its intention to introduce relevant statements of the defendant either without a witness or through a non-precipient witness reader. Under Massachusetts law, statements of a party opponent are admissible in evidence to prove the truth of the matters admitted in them. And that comes from Mass Rule of Evidence 801D2, also Commonwealth v. Lesty. Any extrajudicial statement by party may be admitted in evidence against him by opponent and will not be excluded on the ground of Oh, is that hot mic? Hold on. Let me see something. I heard something.
Well, no, you can't put when something he says is not true. Whole thing.
Sounds like all right. I've got OnlyFan up and it's still OnlyFan. So I did hear, did you all hear that? I don't know. All right. So the hearsay exemption of the party opponent encompasses any extrajudicial statement made by a party opponent, not just statements that are inculpatory or against the party's interest. And that can be unopposable. All right, now there's some action. Yeah, we got a hot mic situation, so I'll put that up for y'all so you can hear the hot mic. Hot mic. They're gathering in there for sure with hot mics on. All right. Let's keep reading through this thing. To admit a statement of a party opponent, there is no requirement that the oh,
What?
what?
Yeah, right there.
Oh, never mind.
That was a great.
That's some tech wizardry. That is that's Lori Vallow from yesterday. Hold on, let me find it. Tech wizardry. Live tech wizardry.
Um,
Okay.
embarrassing.
Is it? Allie says it's super embarrassing. All right. Let's shut that up. So that was from yesterday's Lori Val, not today's. For some reason it just started. Okay. All right, let's get back to this. All right. Okay, so to admit a statement of a party opponent, there is no requirement that a foundation be laid, nor a witness that has personal knowledge of the subject. See generally 14B mass practice summary of basic law. See also causable, wherein it stated that text messages sent from the defendant to the victim were admissible under the hearsay exemption for a party opponent's statements and properly admitted to provide important context for the defendant's text message. And then Commonwealth v. Barnett, text message to defendant properly admitted to provide necessary context to defendant's admissible statements. So the defendant has made numerous statements to witnesses, first responders, medical providers, family members, and journalists, as well as recorded statements on John O'Keefe's cell phone. These statements range from the defendant's immediate impressions and state of mind in the minutes and hours surrounding John O'Keefe's death to crafted narrations, sometimes in the presence of counsel that recount for the defendant's version of impressions or impressions of events months and years after the murder. All of these statements are ones of the opposing party made by the defendant and are therefore admissible. The Commonwealth thereby provides this honorable court notice of its intention to introduce statements of the defendant and can provide the court copies in advance for any preliminary findings of fact that it was the defendant who made the statements. The Commonwealth also moves to provide notice that it intends to introduce the defendant's own statements without a witness or in some circumstances through a non-recipient witness reader. So that's that motion. And frankly, that motion's a little problematic. I mean, the one thing is that Karen said a lot of inconsistent things. She said multiple things that kind of contradict one another. That's the problem with allowing your client to talk pre-trial to the press. It's something that Allison and I are very adamant about our client not doing that for this exact reason. So Tracy sent me this. Okay, and this is Victoria George's motion to jump on as pro hoc. Okay, and if you'll remember, Victoria George is one of the former jurors. She wasn't one of the deliberating jurors, but she was a bonus juror. This is just such a wild thing. I've never seen anything like this ever, where somebody in a retrial was on the jury in the first trial and was an attorney and has now decided to join the defendant's team. It's insane. It's insane. This case has it all, doesn't it? It really does. So this is Victoria George of the law firm of Yannetti Criminal Defense Law Firm and a member in good standing in the Massachusetts Bar, hereby moves to be added as local counsel for Pro Hoc Vice's attorney Alan Jackson, Elizabeth Little, and Robert Alessi, who have been previously associated as counsel for the defendant in the above captioned matter. In support of this motion, counsel states as followed. Victoria George is a licensed attorney in good standing in Mass and is associated with the Yannetti Criminal Defense Law Firm and has served as local counsel for Karen Reed in this matter. On September 22nd of 2022, Judge Krupp granted the motion for admission pro hoc of Alan Jackson and Elizabeth Little to represent Karen Reed in this matter, with David Yannetti serving as local counsel. On November 22nd of 2024, this court granted the motion for admission pro hoc vice of Robert Alessi to represent Karen Reed in this matter, with Yannetti serving as local counsel. George is associated with the Yannetti Criminal Defense Firm, is familiar with this case, and is prepared to serve as additional local counsel for Ajax, Eliza, and Bob. Yannetti will remain primary local counsel for attorneys Jackson, Little, and Alessi. Good cause exists to grant this motion because attorneys Jackson, Little, and Alessi have specialized skill and knowledge in representing defendants in matters of this nature. Should the court grant this motion, I will act as co-counsel during the pendency of this matter. Counsel has been paid by the Board of Bar Overseers registration fee of $355 per attorney as required by the Supreme Judicial Court Rule 315. And she also attached her registration statements for Jackson, Little, and Alessi. So there's that. It's interesting. So it sounds like she wants to have a seat at the big table. She does that because I think that there was some talk initially she was going to be more of a jury consultant. And it sounds like now she wants to have an active role. So interesting. This is also filed. Okay, and this looks like some various things that have been tendered in discovery. So now comes Commonwealth, and the above caption matter indicates that of this date, the following discovery materials have been provided to the defendants through the defense counsel. All right, so the copy of the Canton audit, which we all know about, copy of updated CV of Shannon Burgess, which was previously provided on April 6th. Copy of a transcript of Janet and William Reed interview, Body in the Snow. Copy of transcript of defendant's interview, Body in the Snow. That's the Max documentary. Copy of keeper of records for NBC Universal Dateline episode, Night of the Nor'easter. Copy of keeper of records for Unsolved Productions, Inc., A Body in the Snow. Copy of keeper of records from ABC 2020 episode, The Perfect Storm. And a copy of updated expert contract and payments. And then a copy of CV of Carl Mayasako. Doesn't say who he is. I'm assuming he's probably related to one of those documentaries. And then 10 copy of MSP report number 115, including notes, which was 2 pages. Copy of Ian Whiffin's PowerPoint, 53 pages. Copy of Ian Whiffin's video, 1 page. Copy of Ian Whiffin's report, 3 pages. And copy of video audio clips of interview statements, 41 files. All right, so they turned over a lot of late discovery there. And this, I think, was the last thing that was filed yesterday.
I'm gonna chime in and ask you, is it possible that the defense left breadcrumbs for Brennan, hoping he'd do exactly this with her statements? And like kind of opening the door to get more statements in
Yeah, Allie's over there, side stage.
Tell them what I said.
What'd you say?
Is it possible the defense let Karen talk because they wanted to leave breadcrumbs for Brennan to follow, setting a trap, sort of?
So Allie's wondering if the defense let Karen talk on these interviews in order to leave breadcrumbs to lead Brennan into a trap.
I'll be using all these statements, and then they're gonna.
Allie, Mandy says put a bra on and join us.
I wanted to sleep, but then you started talking.
Yeah, I mean, you're not going to be able to sleep with my big mouth in here. Can't happen. No, we don't want that. All right, so we still got OnlyFans. OnlyFans still chilling. Not that many. They're all over at Melanie's. 244, and I was late. Let's see. Where the hell did it go? I lost it. Tech Wizardry, live and in person. Tech Wizardry. Ah, there it is. Okay, so this last thing that was filed is Commonwealth's motion for notice of any visual aids, potential exhibits, or potential chalks that will be displayed to the jury during opening statements. Commonwealth notifies the court that it intends to introduce recorded statements of the defendant in its opening statement and will produce a copy of the recorded statements to the court in advance of opening statements for a ruling on admissibility. Further, if followed, the recording should be marked for identification so a complete record is made of all items shown to the jurors in the courtroom during the trial. Additionally, the Commonwealth moves for an order that the defense identify in advance any visual aids, potential exhibits, or potential chalks the defendant intends to use during their opening statement. All right, so I mean, it gives us a little bit of a preview of openings. No, this was not posted in advance. I fell asleep last night. I was exhausted. That was a super long day. It's a super long day yesterday. Like I crashed almost right after the live, and then I slept like a little angel. And I woke up 3 minutes before 9. All right, I'm going to put OnlyFans back up because we should be starting imminently. We're actually 8 minutes late, which tells me I could have. All right, there's OnlyFans, and it is live and up to date. All right, I got to go let the dog in. Hold on. I'll be back.
If you turn off the camera, I'll do
It's supposed to be 80 on Saturday here in the Windy City. All right, wait, Tracy sent me another one. That was filed April 4. Yeah, this might be the one too. This could be one. Let me see. All right, so I'll pull OnlyFan off again. I'll throw this guy up. And let's see. All right, so this tells us who Carl Miyasako is. So now comes the Commonwealth and respectfully requests this honorable court allow Carl Miyasako, a senior DNA analyst of Bodhi Technologies, who personally conducted a technical review of the work of DNA analyst Tess Chart in this matter, to testify at trial. Tess Chart, the DNA analyst who conducted the mitochondrial DNA analysis and compared those to the DNA profile of the victim from the known standards in the case, is medically unavailable to travel to Massachusetts for this trial. The Commonwealth seeks to introduce the results of the profiles through the testimony of Mr. Miyasako following his technical review of Ms. Chart's work. Mr. Miyasako will give his own opinions based on his review of the testing conducted by Ms. Chart. Both individuals involved work for Bodhi or Bode Technology. I think it's pronounced Bodhi. Bodhi Technology Labs. It could be Bode, though, obviously. The Commonwealth does not intend to introduce at trial the documents containing the raw data report or chart produced by Mrs. Chart. In Williams v. Illinois, a plurality of 4 justices concluded that introduction of a witness's opinion concerning a DNA match did not violate the confrontation clause, where said opinion was based on a review of DNA report from an out-of-state laboratory, which was not introduced at trial. Furthermore, in Commonwealth v. Grenadier, Supreme Judicial Court held that Williams did not trigger a change in Massachusetts law that allows an expert to testify to his independent opinion, even if said opinion is based on data, not in evidence. Furthermore, there was no violation of the defendant's confrontation rights, where a DNA's expert opinion relied on DNA test results obtained by an analyst who did not testify. In the instant case, which means this case, the Commonwealth is seeking to introduce the opinion of a witness who personally reviewed Ms. Chart's works and who will render his own independent opinion about the DNA results. So we'll see. We will see what that, I mean, I find it problematic. I mean, if they're not going to be getting into the lab, like the data, and they're just giving like kind of a blanket opinion on whether or not there's a match, it'll be interesting to see how Judge Bev rules on this. I imagine she's going to let it in. Let me see what it said on one here. Let me change it to view. All right, so the Commonwealth does not intend to introduce at trial the documents containing the raw data, the report, or the chart produced by Mrs. Chart or Miss Chart. So Masako will give his own opinions based on his review of the testing. So here's the deal. I mean, he didn't do the testing. He's checking Chart's work, and then Brennan's trying to have her or him testify as to what her work was, but forming his own opinion based on the work. So we'll see. He claims that it doesn't violate the confrontation clause. I think it does, because he didn't do the work. He's basically just looking at the work that was done. But we'll see where Judge Bev lands on it. All right, let me bring back up. So I think it's got to be one of those 5 things, if not all of them. We will see what the defense's position is on it. Oh, there's the guy. Just hanging out back there. You guys see that handsome devil? What a guy. What a guy. Andrea Bernhardt tweeted good info about the substitution of the expert. I don't follow her on Twitter. I'll have to check it out. All right. What did you get, Lisa? You twinning? Did you get a t-shirt? I know you ordered some shirts. This is actually the Black Pumas. It's not DD. Black Pumas. Oh, Jim, thank you. Gifted 1 DD podcast membership. No, Sarah, I didn't give you all any warnings. It was I think I started this like immediately after creating the live on StreamYard. So this time it's not actually YouTube's fault. It's probably my fault. I overslept. But thank you. Thank you for your generosity there. Pokemon member, 15 months. OG. Show the like button some love. For real. For real. All right. Make sure I'm up live. Do you guys think sound-wise Boston 10's the best? I know I've heard. Oh, your exercise chart came. Nice. Or your ball chair, yeah. I love my ball chair. I can feel my glutes working all the time. It's fabulous. Fabulous. So what is her name? I have not followed her. Let me see. I'll look for her. Andrea, what's her name? Let me see. You're not talking about Andrea Burkhart, are you? Oh, if it's Andrea Burkhart, of course I follow Andrea. Milo's mom said Bernhardt. Is that a different person? I'm assuming that it's Andrea, who I of course follow. Yeah, I follow. Let's see. Oh, maybe not. There is an Andrea Bernhardt, but she's German, so I'm going to assume that's not her. Her account is all German. Oh, okay. Okay, so you guys are talking about Andrea Burkhart. All right. Of course. You think that I wouldn't follow Andrea? She's my homie. She is my homie. Mm. All right, I'm looking for this April 4th tweet. Let's see from Andrea. If you guys don't follow Andrea's Substack, you should. It's really good. Spends a lot of time on that. All right, let's see. Okay. Okay, so she says Andrea went, oh good, yeah, she did the work. So on the 4th, Andrea said, so Mr. Brennan has either failed in his duty to inform himself of the applicable law before asserting a position in court, or he has chosen not to disclose Smith to the court to advance a deceitful argument about the law. I wonder how gravely concerned the judge will be. Zing! Get him, Andrea. And then she says, naturally shepherdizing Williams, and Williams, if you case, it was the case that Brennan cited in there, shows that Smith rejected it. Okay, so that's what she's talking about. So shepherdizing, if you all don't know, is when you are checking to see if if a case that you've cited or intend on citing in a legal argument, whether it be a motion or a pleading, is still good law. As you guys know, they will oftentimes overturn laws in other cases, because remember the way that the law is created. And I've kind of gone through this summary before with you guys. You know, a bill is drafted, a House bill, if it makes it through the Senate, if we're talking about a state law, you know, and then it gets through both the House and the Senate, then it goes up to the governor, and the governor, if the governor signs off on it, then becomes law in that state. Once the statute's put in place, and then it starts getting litigated, and you know, it's what lawyers do. We all interpret things differently. That's literally what we do for a job. So you got two sides interpreting the same statute in different ways. And in a criminal case, if there's a conviction, it then, if that particular statute is found problematic for various reasons, that'll be litigated up at the appellate court. Or if there's interpretation problems with what the language means specifically, at that point, it'll get brought up at the appellate court level. The appellate court justices will read it. They'll reach a conclusion on it, and then they'll come back with an opinion. That opinion then becomes the law of the state. And that doesn't mean that that's not going to change. I mean, that is always how the law is created. And that's why when we talk about the U.S. Supreme Court, when they ultimately rule on something, that becomes the law of the land. So, and it's with the U.S. Supreme Court is really, it's starting. All right. What are you watching on, Trace? Because 10 doesn't have it starting yet. I'll switch to it. 10 still has OnlyFan up. All right, let's see. I mean, I'm live here. What do you got? Let me see. I'll check. All right. Yeah, I'm going to switch over. Okay. Oh, boy. I don't hear any sound yet, though. Sometimes they're a little bit behind time. That is not me with no sound. Mandy, where's our thing with the circle on it? Tracy, are you hearing sound on are you guys hearing sound anywhere else? No, this isn't me. This isn't me. I've got it live. I've got it live. You can see the little red dot there at the bottom where it says live. There is no sound here. Let me catch this thing up. Huh. Shit. Seems like it is me. Court doesn't have sound. Are you guys seeing that? Court TV has sound. Okay. Let me check that. All right. All right.
But
Let's
there,
start it at the beginning.
all right.
Your Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you, Mr. Brennan.
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed. And then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been in our request.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case. And it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view, she can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously the jurors would be transported the exact same way that they were transported last time. We were on a bus. as I stand here, I can't remember if we were we were not on the same bus as the jurors. And
Yes, we were.
we're just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors, but just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed,
That's
and
fine.
the rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they
They
decide,
want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at sidebar about this anyway?
Sidebar. So they are obviously at this point allowing Karen to go on the jury view. That's the field trip. It's a field trip to the house, which is good. She should have been allowed. They're trying to work out some of the logistics. Field trips are good. I like the concept of the field trip, especially in a case like this, because some of the spatial things that I think will be helpful for the jurors to see in terms of trying to put together actual distance where we think John O'Keefe was found, even though for whatever reason, in terms of their investigation, they decided not to mark exactly where John O'Keefe was found. So they're having to go by memories, but it will give the jury an idea of the distance from the street and the curb to where that hydrant is and the flagpole and all that stuff over there, to give us a better idea in terms of the spatial aspects of it, because a lot of times that's helpful. And as you guys know, I mean, if you guys have ever rented an Airbnb, and you look at the pictures that they use on Airbnb and you're like, wow, this looks like an amazing spot. And then you get in there, it's a shoebox. It's because they're very talented at taking pictures that can distort the actual distance of things. So I'm glad they're going out and doing that. I mean, obviously the conditions are different. That's something that you always worry about. This thing's going to be going on during the spring and maybe early summer, depending on how long it's going on. But, obviously we're not going to have the same conditions, but it does have value in showing the jury what the lay of the land is, which I think there is value in. And as a defendant, especially because she's not in custody, it's harder to do a view when your defendant is in custody, especially if it's a homicide case. Like in Richard Allen's case, initially the defense had filed a motion to have a view to go out to the Monon High Bridge and out to the trails. They ended up withdrawing that motion right before trial, and I was kind of upset they did that. I thought that was definitely a case that the jury should have taken a field trip. I want to say that they did take a field trip. I want to say yes, they did go out there. Like, they didn't have cameras. Like, can you guys remember in Murdoch? Did we watch that field trip? Did they stream that field trip? I know in Reed they did not. There was no cameras involved. I remember that day when they took the field trip and they were out there because they came back and tried to do. Yeah, Murdoch wasn't streamed. Okay. I was like, that would be tough. That would be tough. It's a lot of logistics to try to figure out how a camera person, because they would have been worried about what the camera person's showing. Yeah, Bell, I kind of remember seeing that thing. I don't know though. I can't remember. That was so long ago. That's when Jay and I became brothers with another mother or from another mother during Murdoch. That's when we met on the Twitter machine. It was glorious. It's glorious. Aw, Pammy. I was so glad that you came in last night, Pammy. I was literally thinking during the day, I'm like, where has Pammy been? I miss you. And I notice when you're gone. Just know that. So, aw, family hugs. Welcome, welcome. Cat Grow, member for 4 months. Aw, family hug. Welcome. Bluetooth. Love you, Bob and Allie and family, here for the trial all over again with you. Can't be more thankful for you. Being here with us. Thank you very much. Thank you. We agree.
All right, so on the defendant's list, I don't understand the motion regarding Dr. Welchure, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welchure, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay.
I will do that.
All right, thank
Thank you,
you.
Your Honor.
Okay. So Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those, so those are fairly substantial.
Are there any other changes to it other than the removal role of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor rep parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right,
Okay.
that has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is
Sirens.
extraordinarily experienced.
That's a fire truck.
You will see that in his report. The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites two specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby. And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that, notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's good. That's what we're going to hear
Or
now.
TV's glitching.
Understood. And I was just going to say, I am not going to get into the basis for that. I just wanted to, because.
Just go ahead. Just move on.
Yeah. So my request would
Hey,
that
my little
a
angel.
determination
Pause it a sec.
Okay,
whether or not there's a voir dire.
Court TV's glitching.
Well, check to see if there's somewhere else that's not.
Well, I mean, the problem was like,
I mean, you're
so
streaming the same video, aren't they?
Yeah, the problem was Law and Crime sound wasn't working, and it actually just kicked in. Like, I felt like I had a pretty good idea of what Psychosis might sound like because I had this one going, and then the sound started for Law and Crime finally. So I had Bob Alessi talking like unmatched and two different things he said. It's like blah, 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 saying two different things. So it sounded like that's what it would sound like in my head if I was going insane, I think. And then I was trying desperately. You guys couldn't hear it, but I could hear it. And I was trying desperately to find the second screen. That's why I shrunk it down for a second. So maybe Court TV will fix it. What did you want me to pause for? Kill some
Just
time.
to figure out what was going on with the sound. So the defense is arguing that like she didn't answer their motion, so they had to prepare for someone they don't think should be able to be allowed. What are they getting to here?
Well, they have an issue with Garrett Wing, who's their dog bite guy.
Mhm.
And their issue is that they don't necessarily think they want to have a voir dire of him because they don't necessarily think that he's competent to get up there as an expert. He's never testified in court. They don't know that he's ever employed any kind of actual methodology. So obviously Bob Alessi's like I personally don't love him as a witness because if you don't think that Hank Brennan's gonna, I mean, Melanie Little is gonna get some love, the Cupcake's gonna get some love because if you don't think Hank Brennan's gonna talk about how he's a guy that was on YouTube that the defense decided to pull on. I mean, like he'll take any shot that he can get in terms
Yeah,
of
but
trying
we
to
don't know
trash
that
witnesses.
yeah.
Yeah, no, they would like we see it happen all the time.
No,
See
I
it
was
happen
gonna
all
say
the
we don't
time.
know that that's where they found him, but
Oh, of course it is. Of course it is. Where else? You know
yeah.
what I mean? It's like unless they were watching his, I mean, he does have his own YouTube channel, so maybe it's possible, I
No,
suppose.
it's probably came from
Melanie.
Melanie.
I mean, right. Let's be realistic about it. All right, let's see if they got this.
Here of Lieutenant Wing abide the motion in the discussion. So in conclusion, Your Honor, we respectfully request that have a voir dire hearing on at a minimum, wait for that determination until the court reads the report
Right.
of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right, so there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog.
Thank God we were talking about this
I
before.
think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times. And that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm.
The arm
It
moves,
is in
Mr.
a
Brennan.
objective,
That's the
a
thing.
specific, and a
That's the thing.
substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's
Not a
exclusion,
chance.
not inclusion.
Not a chance.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Wilson.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
Why? Does he need to?
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The substitute chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Attorneys
Okay.
too. Oh, wow, I
So
wouldn't
Jim,
let them do it.
63 is allowed.
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe.
I think that
It's
was
about the audio
DNA
visual
guy.
Pause it a second. I disagree.
aid
I
in
think
giving notice. So you both in agreement to give.
in my opinion, it sounds like the prosecution is going to use this substituted DNA expert to basically say this other DNA expert did the work. She made this determination, and I agree with that determination. So it's like an implicit bolstering of the initial DNA analysis by just
I agree.
So, and I think that that was a weasel way, that was what they were trying to do. And I don't know if the defense caught it or if they just read it like, oh, they need to, they're using another guy. It doesn't matter, because in some situations you might not give that a second thought. But so we'll have to watch a trial and see if what we're thinking is completely wrong and he just simply,
Well,
called us.
they in the notice that was filed, he says that he's going to give his own opinion, but they're not entering any of the data, any of the raw data
Right, but I
or
still
the
expect
charts.
that opinion is going to be like, I reviewed this other it essentially implies that
I
both of us
agree.
agreed to the same thing.
Right. It's like you're getting two witnesses for one. It's like you're getting two
Right.
people from the same lab saying, "Oh yeah, we both think it's his DNA."
Right.
Because the interpretation
One.
of DNA is very subjective. I mean, that's like a DNA profile. Once it's created, every lab tech in the world isn't going to see it the same way. That's the whole point. So I agree completely. They're getting two for the price of one. They're going to get to say, oh, this other tech did the work, and this other tech, Dr. Charts or whoever, lab tech Charts, she found that this was a match, and I agree. It is a match. So yeah, they are. But I mean, they're for whatever reason, Andrea found that the case law they cited was bad law. She shepherdized Williams and said
Wait,
that there was
the case that who cited for what? What are you
Brennan
talking about? For which? For the DNA?
for getting this guy in. Yeah. They cited this Williams case, and Andrea had gone and shepherdized it, and Williams was bad law according to Smith, which was a later case. So, I mean, it sounds like they had a way to fight it, but I mean, maybe they're
Yeah.
not overly concerned with it.
Right, but is it because they're not seeing a problem that they should, or that we're finding something where there's not? And I guess we'll see once the
Guess
trial.
we'll see.
Give notice to the other side before you use anything, and have you done so with regard to openings?
This could be the
Commonwealth
last
agrees to
motion.
give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's
I am,
going
Your
on?
Honor. We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the defense what you intend to put up?
This is a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you. So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank you.
all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay,
Can I make a note?
yes,
So-
please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay,
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have
I
that.
think Brennan's going to try to get Keith
take the
Morrison.
stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
all right. How are you going to find this person?
But we could have somebody playing close from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay,
May I have a moment, Your Honor?
yes.
And Karen Reed, she then said the following, and I'm Keith Morrison. I mean, do you think they're going to have like I'm assuming, I guess, I don't, that's weird. That's a weird thing to do. Having like a set reader of all Karen's quotes, all of her extra judicial statements. Yeah, I don't know. I think this is the
Your
last
Honor, thank you
one.
for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Garino is an independent witness in this case. To bring him back regularly as a police officer, I think is creates the wrong impression. I think objectively,
Okay.
we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Garino is the one who found, if he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be. And the text messages are admissible because they're their statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps, not a state trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard
So-
him, I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
How do you know, Brennan? How do you know that there's not going to
All
be
right,
any
defendant's
inflection?
motion for specific
shit.
discovery, paper 638, Jimmy. All right, who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay, there's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where? Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Positive
Okay.
side, babe.
I'll hear from the Commonwealth.
So if you remember, the Rule 14 was recently amended to be very expansive, to include a lot of things, and absolutely positively anything that would show bias for cross-examination is relevant and discoverable. Period. The end. The judge has got to revisit how expansive that new rule is, as she herself identified in her ruling of the motion to dismiss. So, I mean, you'd think she'd be pretty much on top of it.
I thought
Where is that covered in the rule?
I thought that she cited that the rule had been amended, but then was using the old language.
Well, because she was talking about what was in place at the time that they wrote their discovery demands, and the state made their complied in air quotes loosely
Yeah.
with their obligations.
I think that they should have AI read it. AI could, like, you could probably put a prompt in there to have zero inflection. Yeah, let's bring the robots in.
Zero inflection.
I am reading, I am AI. I will have no inflection in the following statements that I am reading. I'm telling you, it's coming. It's coming. You're gonna be doing it soon.
Number 5? Yes. With regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of
Puppets.
any witness regarding promises, inducements,
You'd have,
or rewards to that witness.
Bob Senior puppet read it.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you.
Babe, pause this.
All right. The ARCA witnesses.
Bring up, do you have that motion 3 and 4? So this is the motion.
Handy? No, not handy.
Well, let me see. I think we do.
Well, we definitely have them, but you're gonna have to look for them for a minute.
Right, but it was the
I missed what number it was.
yeah, it's the one about
No, but she always says which number motion it is, like 683 or 6, you know what I mean?
yeah.
Well, if you want to look, we'll play it while you're looking. It's gonna take you a hot minute.
Oh, it's probably this one because it's right after the motion for. Oh no.
All right,
I
I'm gonna
found
play
the
it while
all
you're.
right, go ahead.
Motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are two issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant.
All right, what
So
is
if the
this
defense
idiot
position is
talking
not in
about?
their custody and control,
Pause
then
it.
I ask the court to order the ARCA witnesses to provide that information.
Clearly, if there were text messages between the defense team and ARCA, that would be in their custody and control, sir. if there were emails and the like between the defense team and the ARCA people, that would be within the defense's custody and control. So why is he acting like a complete moron? Like, hey, we still need this stuff. They said it's not in their control, so it must be in ARCA's control. No, no, sir. It must not exist.
Prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails.
It's because they haven't done any new testing. You fucking moron. Like, does he think that they've been now independently retained and now they've done more testing? Like, it's the same testing, Hank. Same shit. This guy just really keeps trying to push them into the biased category. And it's not happening. It's just
Well,
not
we'll see how
happening.
she responds because she seemed to actually buy into it a little bit the last time this issue was before her.
The testing is the testing is the testing. And it was done when it was done. Period.
I
End
mean,
of
preaching
conversation.
to the choir, babe.
What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports.
Oh, he
We
can
have
rebut
been
your shit.
steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to their February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two
They
things
can't provide any
to
further
simplify
ideas.
it that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Okay, who's arguing this?
I want to go in reverse order briefly, if I could, concerning the discovery deadlines. We have continued to receive new discovery, new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but
What do you think a timely manner is? What ballpark are you talking?
when I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. That's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed. So this is not.
I find this to be a very important beard conversation. So an Amish beard, they don't grow the mustache. They just have the full beard, no mustache. So this, like this here, where you just grow the goat and you trim it down here, that's a straight up goatee. He's got this weird hybrid where he didn't connect his sideburns to the beard.
God,
And
Bob is just fascinated with this man's.
no, I
beard
hate it. I don't
situation.
like his beard.
I know,
I
but
don't
you're
like-
fascinated by the fact how and why it's done and that
I
it
don't
exists.
understand why he's doing it unless he can't grow hair from his sideburn down to connect the beard. It looks bizarre. It's got these weird wings, beard wings. All right, enough.
All right,
of that.
wait, before you do that, I have to say two things. One, the prosecution somehow seems to get away with that, like, oh, our lab just gave us a new test result. We can't help it. What can we do? And somehow that seems to fly. But it's very unusual for the defense to be like, well, my guy's out doing more testing. It might be doing more testing, might not be doing more testing. But as soon as I get a report, I'll give it to them. And, like we see in, for example, those of you watching Lori Vallow, the judge is like, well, your guy can do whatever he wants, but it's a little late for that, buddy. And we're, it's not happening.
I mean,
So-
to your point, I don't know if you heard it, but in the notice of discovery that
Yeah.
they tendered recently,
all new stuff.
they turned over a copy of Ian Whiffin's PowerPoint, which was 53 pages, copy of Ian Whiffin's video, which was one file, copy of Ian Whiffin's report, 3 pages, on April 12th. So obviously Ian Whiffin has been involved in the case from the onset. And why is it okay for them to turn over shit on April 12th?
I mean, I agree.
Theoretically, it would obviously you agree. I was
I just
supporting
wonder if
your
the judge will be like, well, does 2 wrongs make a right? You didn't object. Put it in front of me. Tell me to exclude it.
She could say that. Definitely. She definitely could say that.
Not unusual. A party says, we asked for all 13. Another party says, we gave them to you. And then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
What?
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all the communications, all the text messages, all the emails between the parties.
How do you
And if
know?
The defense's position is not in their custody control. Well, it's certainly in the custody control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
The
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
Right.
So
Boom.
address
Desperately does
number
not
one, please.
I
Okay.
am. That's what I'm doing, Your Honor. We have provided on April 12th, about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Welchure. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied with.
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better?
What?
They said we.
Did
They
you-
talked about we did this, we did that.
Well, not a
I
trial.
would disagree with that. Dr. Welchure talked about what he did, which was more on the biological
I get
side.
there was a difference
Right.
between the
And
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult counsel just for a moment?
Sure.
It's like, well, wait, I know something relevant here.
Right. Ms. Little I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes.
They
Yes,
did.
that is on, that's
Can
on the
they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely. That is on the table. Every bit of testing, every bit of analysis
But
that
why
they
they
did,
did it?
what their communications were, what their directives were, that is confidential. And
Can I see Councilor Tagbar, please?
Oh God, I don't understand their issue, and I honestly don't understand the feds issue. I mean, what did they is there something they're hiding? The feds? Like,
I mean, I don't think so. I mean, Brennan's super paranoid about the DOJ and the defense team. Like he is completely and totally of the
off the rails.
mindset that there was some kind of like backdoor deal, behind the scenes deal between the defense and the DOJ that got them involved and pulled them into starting this investigation. Like he's just obsessed with it. He just thinks that somebody on the defense had some kind of relationship and got them to bite on this. And that because of that relationship, that they went into this thing with a bias, with a preconceived notion, instead of going into it, fully objective. I mean, obviously he cannot prove that. Obviously, it's just him speculating.
I
He's
mean,
just a weasel. He's just
here's the
like,
thing that the judge is concerned. Okay, think of it like hearsay. They can't talk about what their directives were, what was said to them, blah 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 blah, but they can say whether or not they were um, told to aim for a certain outcome without saying what that outcome was. You know what I mean? They could, which I'm assuming the answer is no. If they were told what what end or what hopeful findings that the feds wanted them to make, what determination they were hoping for them to find, and they can say no, they didn't tell us anything like that.
well, I think that it's pretty simple. I mean, so are you saying that you think that they should have to turn over whatever the Department of Justice requested of them? Why would they have to do that? I think in terms of what they were asked to test, they both testified to it. You know what I mean? I've never heard of a situation wherein every single conversation that has been had with an expert witness has to be tendered over to the other side. I mean, to me, that's insane. I mean, because we know, like, in terms of what they were supposed to, did the vehicle damage result as a pedestrian strike? Okay. And then were the injuries to John O'Keefe consistent with a vehicle strike? I mean, those are the two things that they're supposed to figure out.
Right.
That's
So no,
it.
I mean, I'm just saying, like, if Brennan's trying to get at them saying, well, we're of the mindset that the car never hit the person, and we'd like for you to prove that. Without getting into their communications, they can say, did they tell you what they're hopeful, what they hoped you would find, what they expected you to find, the way they, something, come up with questions along those lines that would resolve the issue. And why do we think she is going to a sidebar again when there's no jury present?
Yeah.
Unless it's to get some information that was produced under a protective order by the feds that they can't share to us, the public, about something the feds said or did.
Yeah, I agree. But Mama Bear, this right now is a sidebar. This isn't a pause. They're up at the bench.
But we might
mean,
have
what-
looping time.
Oh yeah, we do have some blooping time. Well, maybe a little bit. Yeah, we've got about 2 minutes of bloop. Yeah, Mama Bear, we're never not going to pause. I mean, it's not happening. I mean, you could watch on Court TV if you don't want any commentary.
Well, plus
Um,
people don't like when we talk, we talk over.
Right, but you don't you have to pause if you're not going to try to talk over the examination. I mean, we're both lawyers. We think we bring value to it. So
Mama Bear's usually here, I think.
yeah,
recognize
I
the
think
name.
I saw Mama Bear complaining about the pausing yesterday too, though.
Well,
I
maybe
mean,
she's excited.
I mean, but we're a great duo to watch because we pause and give commentary. Otherwise, we're just sitting there, right? I mean, we have to pause
I'll just sit here.
occasionally.
I'm tired.
No. I mean, right now we're not paused. It's a sidebar. Now we're live.
Not try any additional thing, did not. Mr. All right, so Mr. Jackson, you're saying that the ARCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti. And you have that all documented, whatever information the ARCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the days. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA
Do you
to
know?
answer their questions.
Do you know what information was provided?
Yes, it's in the report. There
All
were
right,
14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you
September
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welchure, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welchure was provided.
All right, so when
that's
did you
what
do?
we provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion.
Okay.
Additional discovery for the experts for their review on March 26, 2025. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welchure's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welchure had, as well as Dr. Welchure's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh,
You
I
said-
didn't say 3 days. I said, I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right,
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
all right. Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionist they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judge Welchure's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7th, 2025. Your Honor, I ask you to allow ARCA to testify. allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
Our argument to this is simple. I mean, how does Hank Brennan expect the defense to be able to rebut what Welchure's saying until Welchure gets the report to Hank Brennan, and then Hank Brennan gets Welchure's report to the defense, which happened in March? Is Hank Brennan suggesting the defense shouldn't be able to rebut their expert and their expert's report? You're muted.
Right.
I mean, what the fuck is he talking about? I mean, that's what he's suggesting. He's sniveling about the communications because of whatever he has in his mind in terms of the collusion between the DOJ and the defense team. That's all bullshit. In terms of the issue of the late disclosure by the Commonwealth in terms of their new testing by their new expert, is he suggesting that the defense shouldn't have the opportunity to rebut that at trial? Because that's what it seems like he's suggesting to me.
I mean, it does seem like that's what he suggested.
Does it not? And he's butthurt about it. This guy's so full of shit. If Canoni fucks this up, I'm going to be really pissed. This is like a simple argument here.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welchure's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welchure's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander.
Good for the goose.
Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welchure's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted. And we're moving forward as expeditiously as we possibly can.
Oh, God.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judge Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the
Well, that's
report,
some
so we
dipshit.
took things
I don't
out
know how to say
of
his
the
name.
report.
Ugh.
There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025.
Exactly.
And then
what
on
Jackson
February
said.
5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
Well,
According
That's-
to
that-
Mr. Alessi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judge Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right, thank you.
take it under advisement. We don't want to have time for you to take shit under advisement, Judge.
I think is the only thing left the
Yeah, she got the weekend.
motion to sequester Aiden Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to,
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct, which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
all right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of,
Excuse me?
we need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right, get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay.
Um,
You know what? What I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as, it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway, so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
Negative. Not going to rise for the court. All right, so we have a little blooping, not much blooping. Yeah, no, I mean, she'll get the stuff ruled on over the weekend. It's a long weekend. As you guys know, there's no court on Monday because of the Easter holiday. And it's starting in earnest on Tuesday.
In earnest.
In earnest. Yeah, I think we're live now. I'll just scoot it live. We were behind time a little bit. Not too much though. I don't know what time they actually went on break. Yeah. I'm ready for this thing to start. Enough with all this bullshit. Boy, Hank Brennan just really bugs the shit out of me. Like, I cannot recall and I've had some prosecutors and defense attorneys bug the shit out of me, but I cannot. He just grates on my nerves. And I'm trying to figure out if it's because he's a turncoat. I don't know. Like, in my mind, if he just irritates me so much more because he is a defense attorney who's turned special prosecutor in a case that's utter bullshit, and he's going so hard on it. It seems gross to me. I can't put my finger on it, but like, he really makes my skin crawl. He really does. It's just like, I mean, his voice, look, I'm going to be mimicking this guy. Like, my Brennan shit is going to be legendary. Like, people will be coming to this channel just to hear my Brennan fucking, like I'm serious. It's going to be like, I'm going to be working on it all weekend, 17 to 18 hours a day, just mastering my Brennan. I joke, but I will definitely be doing some Brennan. But like, seriously, he just really, really pisses me off. And I tend to think because this guy, he's like a mob lawyer. This, like, Allie, this is the equivalent of Joe Lopez.
Nah,
The
he
Joe
would never
Lopez
do it.
that we know, trying a case.
He would never do it, but he's.
You say that.
Hardcore.
If I would have known Hank Brennan, like back in the day, you'd be saying the exact same shit about Hank Brennan. What? He'd never, like, he's a defense guy through and through. Because we as defense attorneys, like, we're a strange tribe, right? We just are. Like, we're all used to the beatings that we take, and it's just, I don't know. It's driving me nuts. And his like Alan just nailed it with the feigned indignation thing. It's exactly what it is. It's like everything that he's doing seems like feigned to me, meaning fake.
But I mean, I would be up in arms if the prosecution came in and
With
was
like a
"We got new
Sallyport
expert."
video in the middle of trial. Would you be up in arms? Like they can't bitch about the same shit that they did in the
Well, no, but here's the problem here. The defense asked for a continuance for this. The judge said no. She's got to give them this leeway. So that Brennan's issue is with the judge.
Well, but that's his issue with the judge then.
That's what I'm saying.
Certainly in his argument, he wasn't making it sound like his issue was with the judge.
No, he
was
wasn't.
making it sound like it was with the defense, like they were slow playing this shit. He brought up his trial by ambush bullshit again. I mean, here's the bottom line: as far like, forgetting about the communication shit. Like, just forget about that. Like, to me, that's a non-starter. I don't care about it. That's all in Brennan's mind, like about this shit, about this nefarious thing that's going on. I mean, obviously, he's terrified of ARCA. Obviously, the concept to Hank Brennan that ARCA is going to be able to review Welcher's work is not attractive to him because he knows that ARCA is a better witness.
Right.
So, I mean,
But
like,
that's
that's
like
where
you're
this
saying that
entire
there,
thing
he
is.
doesn't get to bitch that somebody is challenging his witness.
Well, that's the only thing that matters. I don't give a shit about the communication
no,
stuff.
no. But the defense is saying that they might do new testing. That might not just be, I mean, I
No,
guess
they,
it's
the
all sort
defense
of
has asked ARCA to review Welcher's work so they can rebut it. Like, that's out. What Brennan's saying is he's like, no. They can't do that. They can't do that now. It's too late in the game. It's trial by ambush. So that's why Jackson, like, were you not listening to my
no, I was, but I
Jackson just
kind of
mimic
see it as two
exactly what
different
my
things.
huh?
I see it as
I
two
couldn't
different
hear you.
things.
I was still talking. What were you saying?
I see it as two different things. Like one, they're challenging his expert, and two, they're doing additional testing to round out their defense.
Well, they want to be able to rebut Welcher. Of course,
They,
it's to round out the defense.
but I'm saying I think it's sort of two different things.
I did not get the impression that they asked for additional testing for essentially their case in chief. I didn't get that sense. You know what I mean? I mean, maybe. I mean, I would. I'd certainly be trying to, but that's a harder
Right.
argument to win because they didn't have to wait on anything. There was no reliance on the Commonwealth for
Well,
anything.
but they said they were waiting on
Was
the
to get
the
approval that
feds.
Arthur was going to be able. Well, yeah, or Canoni saying that that ARCA was in. I mean, but still, I don't get the sense that that's what they're trying to get in. I like additional testing above and beyond where they're working about, where they're trying to get Welcher's shit rebutted. So, I don't know. I mean, like if you're Karen Reed, you want ARCA doing as much testing as humanly possible. What's going to be admissible this late in the game, and it is a valid argument. I mean, Canoni slow played her decision on whether or not ARCA was coming in. That shouldn't be to the detriment of the defendant. I mean, you shouldn't be hamstrung because I mean that you're not going to pay good money to ARCA, not knowing whether or not number one, they're going to be allowed to testify at all. And number two, without knowing whether or not
I don't think.
Canoni
Oh,
would
sorry.
allow it in.
I honestly, in my opinion, I don't think that the defense could fairly argue that they didn't do something because they thought Canoni was going to keep it out because that was never happening.
What was never happening?
That they were going to be not allowed to testify.
Well, I mean, we knew that.
Well, right, but I'm saying I don't think the defense can fairly, honestly argue that they delayed anything just in case Judge Canoni.
Wow, really? Would you
I
make
don't.
that argument in front of Judge Canoni? Well, Judge, even though your ruling was pending, we knew you wouldn't do the wrong thing. Is that what your argument would be to
Well,
her?
but every time a defense team gets an expert, they bear the risk that the prosecution's going to be able to exclude them for one reason or another, or attempt
Yeah, but
to.
this is this is a much different timeline than what you're talking about.
I don't
Like
know.
they had already testified at one trial. You know what I mean? I mean, it's like everybody knows what the testimony's going
I
to
think the
be.
whole thing was they were not allowed to retain them before, and now they were.
Right, but I mean, to retain them for what purpose? That is one of the
For
issues. But
as their defense to do whatever the defense wanted them to do as their defense expert, as working for them.
oh, you would have heard a much more feigned, indignated Hank Brennan if they had done additional testing that wasn't related to Welcher. You would have
I
heard
think
much.
they absolutely were doing additional testing that wasn't related to Welcher.
Did I miss
But
that,
it
y'all? I
but
didn't hear
technically,
that.
it's all kind of related to Welcher because he's saying the exact opposite of what they wanna say, so they could definitely bulk it into all of that, but What I heard was as soon as we were allowed to employ them, we jumped on it and asked them to get moving as our defense expert.
Yeah, I didn't get that from that. I mean, because like we would have heard about a newly tendered report
It
with
hasn't
new
been tendered
findings.
yet because they haven't done it yet. That's what the whole this entire argument is.
Yeah, I'm gonna have to go back and listen to it. I wasn't hearing that. Like to me, the beef seemed to be about the rebuttal of Welcher because Welcher's gonna come in and say that John O'Keefe was hit by the vehicle.
Right, that's why I'm saying it can all technically get bulked in as a counter to a rebuttal to their expert. But I definitely got the sense that they were saying as soon as we were allowed to retain them, we did and told them to, go.
Charlotte's saying that AJ said, "I don't know," when asked about additional texting. That's not a good answer.
He did. He said that he doesn't know if they're going to do new
Yeah, but that's not a
testing.
good answer.
I agree. It's
Now,
like, how
that is
don't
the
you
answer that
know what
keeps all your additional testing out. Like you don't know. You
But it
don't know
could
if you
be, let's
tested.
say, the only reason it could be more in line with what you're saying is he doesn't know if these experts have decided that to challenge or rebut the opinions of the state's expert, they want to engage in some testing. So that's different, like than what I was saying, that the defense is like, hey, go do some additional testing for me for my defense. And that does make it fall more in line with what you're saying, that he's combating, their expert is now rebutting what the prosecution expert says, and he's got no idea if as part of that, they're going to make a decision that they need to engage in additional testing.
Well, I think it completely doesn't fall in line with it. That's what it is.
Right.
I mean, if Welcher's produced a report saying, okay, this is how John O'Keefe was hit. This is how the arm injuries occurred. This is how he ended
did.
up 15 feet
Right.
in the lawn. So like that's exactly what they're doing. They're saying, okay, we're going to do the testing that Welcher just did to disprove the fact that it could have happened the way that he's saying that it could have happened.
Or
I mean,
additional testing to disprove the fact that it happened the way he said it happened.
well,
Right.
that's what they'll have to do is like their own testing, not necessarily additional testing. They'll have to challenge his theory by doing their own testing, right? I mean, but that's what I'm saying. That like that's all one category, like the Welcher category. Just put that in the Welcher bucket. What I'm like, are you suggesting that they wanted additional testing, not necessarily related to Welcher's opinion and challenging that, but something else completely? Like we want you to go beyond, beyond the damage to the vehicle and beyond John O'Keefe's injuries. We thought of another thing that, like, say for instance, let me finish. Like, say for instance, the taillight video that we showed with the guy, where what the taillight would actually look like. Like, would it seems like ARCA would be good witnesses to be able to do that taillight.
And that would be rebuttal too, wouldn't it? They have a new expert that says that it didn't happen from that incident. So that would be rebuttal too.
Theoretically. Well, do they have a new guy who's saying that the
Prosecution
taillight
does. Yeah.
Who?
I'll be back.
Okay, you guys know we're both lawyers. This is what we do for a living. We're not really arguing. This isn't a marital argument. It's a legal debate. It's what you pay us for. And I say that in jest in terms of you paying us. So yeah, like I'm adamant about it. Like, if she somehow stops the defense, like I can't see a world in which she's not going to allow the defense's experts to rebut what's his face. You know what I mean? Like it's like, I know, Kai, like some people that might come in and be like, oh my God, they're really arguing. But I mean, we're lawyers. That's what we do for a living. Like everybody who's used to us at this point knows that, but newbies might not know. They might be like, oh my God. They're like,
they think we're relationship fighting. That's the way lawyers,
I know. It's like, no. Kai was joking, but I was saying, you remember in the early days when we come on and we'd have a spirited debate, people like, oh my God, they're really arguing. And I'd be like, no, we're just
but I don't know that it was like a real legal spirited debate like we're having right now.
Oh, you mean back in the day?
I don't even think it's all that spirited.
Right. I mean, considering how spirited we can get,
I'll show you Spirited.
I'll show you Spirited, girl. Yeah, so no, I mean, but I was saying when you had to dip there for a second, you know,
I grabbed
I
some
will
water.
be really upset if somehow she precludes ARCA from being able to rebut Welcher's shit.
Okay.
Court is back in session. You may be seated.
All right, so the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to.
Oh, wait,
find
there's
the
more?
original.
Okay,
That's the audio, but there will be the visual with it that was aired.
okay. I was able to see the video.
Super.
Okay.
Oh,
All right, were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay,
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
okay,
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so
Pause it
we
real
will
quick,
continue
babe.
to discuss that. I'm not as concerned in terms of timing with that particular issue.
I almost think they should always use Attorney Little to make any argument that they think, you know, the judge might rule against, because she believes her more. She gives more credence to what she says and when she says it. And I think she just has more, like, I guess, trust in her. You know what I mean? Oh,
Are you
Oh.
talking about Eliza?
yeah.
Well, I mean, I think I don't know about all that, but I think she's got like a lot cleaner track record in terms of like in Canoni's mind, she hasn't pulled the same kind of shit that Yannetti and Jackson have in Canoni's mind.
Right.
Like
So when,
Eliza's, she's clean. She
right.
clean. Like Alessi's the same way. He clean. Like they don't have any like purported shenanigans.
She's got issues with Alessi, though. You can see it in the way she talks to him.
Like if she needs to be doing this shit to Bob Alessi. Like all
No.
he does is bring in facts. Like
Yeah.
that guy is the most prepared attorney out of any attorney in that room. He does not walk into that courtroom without being prepared to the hilt, knowing
Well, she
every
might-
single thing. He's super efficient and he's super educated about what he's arguing.
She's got, I mean, I can see it in the way she's always saying things like, okay, could you not tell me what you're going to say before you say it?
Well,
We-
but that's like that's formal. That's form over
I know,
substance.
but she
type
gets,
bullshit.
she gets kind of, I don't want to use the word
Right,
bitchy, but
she
bitchy
takes-
with him.
She takes a little issue to his pandering. Like she thinks that he panders to her too much. With his overly effusive, "Oh, Your Honor, I think you're the most brilliant judge in the world" type shit. And like she's like, you know what? Table that. Just get to your shit. I mean, I think as a general proposition, Canoni's long over this case. Like she wants to I think if people think that she's like just chomping at the bit to sit on this second trial, they're nuts. No judge. It's like Hitler said. Like Mandy's got that quote that we use from Hitler. He's like where he says, I don't want to come out of the box telling you an untruth. I'd be lying if I said that I'm happy I'm sitting on this case. It's like, but Miss K, that's not it's
I
not her
agree.
corner to be backed into though.
But
But I think if you're saying like in the sense that he provides really, really solid arguments that do force her hand, then yeah,
that's
I
what she
agree
said.
with
That's
that.
exactly what
completely.
she's saying. At least
Yeah,
I don't want to
I-
speak for you, Miss K, but that's how I read what
Yeah,
she's saying.
I agree with that. It takes that ability to hang her hat on certain hooks away because he's that effective for sure. I definitely agree with that. All right, let's see. Yeah, I mean, Liza, And did you watch all the Max thing, or did you watch like a majority of it?
I watched
She
the
was pretty
majority.
heavy in it. I like you really got to know her quite a bit more. And she's a good lawyer. She's like I had her pegged as way younger than she actually. She still gets that quiver in her voice in court that you did not hear on the Max thing. I think, but it doesn't stop her from not performing well. You can kind of hear that quiver in her voice. That I mean, it's scary in court. It just is.
Issue.
Okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
See, I'm not hearing
Okay.
it there.
Can we address, is it something you need for your opening?
It's not.
It's
no.
Okay. All right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out. All right.
Thank you.
Okay. So now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay. All right. Morning, Mr. Bradle.
Good morning, Your Honor. No, here's the. All right. So
Okay.
before they start, I'm going to pause it real quick. Essentially, what this is, Turtle Boy Aiden Carney has filed a motion seeking to pull him off the sequestration list because remember, Brennan named him as a witness. Now, the thought is that they did that in order to keep Aiden out of the courtroom during the course of the entire trial, which that has that effect. If he's a named witness, he is excluded from sitting in court every day. Aiden, of course, is a reporter. He is covering the case. He wants to be in that courtroom every day. I don't know how he's getting in because I thought I remember Judge Canoni saying, all right, this is limited to only real media. She was pulling a gull. So, like, I don't know what the line situation, how that thing works over there. So, but he is in court this morning arguing that he should be exempt. We know that Gretchen Voss, who is also named as a witness, was exempted from being sequestered out. So that's what this argument is.
And I just want to say, when you have a witness whose testimony is not subject to change based on all of the other testimony, meaning like he's not going to change where somebody was that night, how, like his factual scenario is not going to change. It's more of an argument in support of, excluding them from the sequestration because there's nothing they would hear that would make their testimony subject to change. And there's other ways around it. Like, well, when this person testifies, we do think that that's directly relates to his testimony and he shouldn't hear it before he testifies, blah, blah, blah. But let's see how it goes.
Yeah. And I'm going to flat out say this. He absolutely positively deserves to be in there. We love him or hate him. The bottom line is we are not watching this trial had that guy not been all over this shit. He is, without question, the person who put this case on the map. He deserves all the credit in the world for that. And again, you can detest the way that he speaks to people or about people. That's fine. But in terms of digging this story up, he deserves to be there. And I'll die on that hill.
And bringing it to the masses.
Well, that's what I just said.
Right.
That's
Sorry.
exactly what I just said.
Jim, you have that. All right. I probably have it here too. I have one, Jim. Thanks. All right. I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradle. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
So
Yes.
Are you asking that Aiden Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness.
Carney.
We'll have to assess that as the case progresses. The other is rebuttal. If
That is the one thing that I can I could feel Hank's pain on
Well,
because
but that's because you're looking at the name when you're saying it. He has now heard his name. No, I mean, like, how many times do you have to be in court where the case is announced to know that, you know?
babe, he doesn't say Bob Alessi's name right. He keeps calling him Alisi. Like, and this is a fellow attorney who's been in this courtroom out arguing his ass for months.
Right.
The defense calls the defendant to the stand, then it is strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradel.
All right, thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Carney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness intimidation.
Okay, so just focus back on.
So the answer is yes. I'm sorry. The answer is
They
yes,
can't
Judge.
call him,
Okay.
so you can exclude him.
So let me hear from you.
His
That answers the question.
yeah, absolutely. Like so what Allie's saying is, like, if he's taking they can't call him. You cannot call a witness to the stand that you know is going to assert their Fifth Amendment right. Allie's absolutely right. That should allow him to come in. His chin is not nearly big enough to be Jay Leno.
You on that, Mr. Brennan?
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was, I'll hear you, Mr. Brennan. And you.
Oh, I'm sorry.
But that's okay. I don't want to hear about
Got
the
it.
witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
I like Tim Bradel a lot. I think he's a good lawyer.
Your Honor, you have questions?
Yes.
He's pleading
What
the
if he
fifth.
takes the fifth?
If he asserts his Fifth Amendment privilege,
He has just
I
now.
think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he
Did?
actually asserts his Fifth Amendment privilege,
Actually
I
did.
would no longer have a good faith basis to say that there would be a need for sequestration. I
Well, he
would
just
ask
did,
the court
Mr.
to
Brennan.
impose the prior limitations with named victims and also minor witnesses.
Okay.
But I
And
would, as a predicate, he would need to assert his fifth.
He did.
do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation. If he wants to assert the Fifth Amendment privilege, we can assert it.
No,
Okay.
that's
Do you
not
want
the
to
way.
call him now and do that now, Mr. Bradel,
Wow.
or not? Do you want to talk with your client? And
Aiden's got a massive
Sure.
heart on if he's going to get on the stand and get to his.
why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Wow. What about the drama
Everybody's
here,
doing-
Brennan?
Mr. Bradel, why don't I give you
Seriously?
10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
Yeah, and talk to the other lawyers. I don't understand why. I mean, I guess technically he needs to say, I am going to follow the advice of my counsel and plead the fifth.
Yeah, I mean, well, I mean, look, he's in the middle of a 17 felony count case, his own case that is like absolutely intertwined with this case. I mean, like
So-
he had,
If he pleads the fifth in this case,
right.
can they offer that as evidence in his case?
That's research that, babe, because that's a great question. Like you guys see the issue with that, right? What Allie's talking about? If he takes the fifth, if he asserts his Fifth Amendment right here, because look, if you like, there is an absolute inference that is drawn from people that are taking the fifth that they have done something criminal, and that they are asserting their right not to out themselves as to their criminal activity. So what Allie's saying is, like, if he asserts it here, okay, then can they then use that in his case in order to try to impute guilt in his felony trial? It's a really interesting. It's a really interesting. Bradel better double check on that, unless Bradel already knows the answer to it. I mean, you would hope if Bradel is going to, like, because what you don't want to do if you're
Yeah,
Aiden,
so the answer is no. I'm pretty
so they cannot
I
raise
feel
it.
pretty confident about it. I just was starting to think, because that would obviously violate his Fifth Amendment right, by saying he pled the Fifth Amendment. So
But think about yeah, I'm curious. Like, I want you to research it though. I understand that you think that it's
no,
okay, but
I just did some quick research, and like if
what did it say? Exactly. I mean, we got time to kill anyway.
Hold on, I shut it down.
Because it's a really interesting question. Because I was thinking about Guevara, like, so Guevara, when they called him as a witness in like one of the exoneration cases in particular, and he took the fifth like 65 times. Now, he's never been charged, but I find it hard to believe that they wouldn't be able to get that in as it was sworn testimony. What, you know what I mean? I don't know. It seems, how are you keeping it out? Actually, she is. She's not my paralegal. She's just the greatest legal researcher that I know. That's more of a tip of the cap. Oh, let's see. Oh, let me see. I got some blooping. I mean, don't y'all remember when Allie found the case, like, while we were watching? What was that, babe?
Yo no say.
No, you know,
I can't
it
remember.
was well, we were watching Reed, and you found the case that they ended up citing in their motion
Oh yeah.
while we were watching it. That's how good at legal research Allie is. So, all right, I think I'm live. Right, yeah. Oh, were they trying to say Andrea found it? Oh, come on. No, there was one crackhead who was like,
No, Andrea gave me
props.
shouted me out about it.
Yeah,
She
Andrea.
actually- I think
Andrea.
she retweeted my tweet, and then
Yeah.
she mentioned it when she was on a live with us that she saw my.
No, some pinhead tried to challenge Allie about like how she didn't know how to read a case or some shit. I'm like, wow, that's funny. That's hilarious. Let's see, Darlene D. Could his counsel argue he took the fifth because of the pending case? Well, I mean, that's why he would be taking the fifth.
Right.
You know what I mean, Darlene? Like that's like they couldn't, like he's got
Because
this
they're
pending case.
misinterpreting. That's why he argued, because their misinterpretation of the statute might place what he said, might place him in jeopardy by what he says, not because it's actually criminal, but because they have misinterpreted it as criminal, and therefore it puts him in jeopardy.
Right. Or they've weaponized the statute in a way that it's not intended to be used, which like both arguments exist. And I think, babe, we're still waiting for a ruling on their motion to dismiss, as far as I know, in Carney's case. Because I thought Bradel put together like a really strong argument and their motion to dismiss, and I don't know that he's ruled on it. I think that might, if anybody knows out there, if that's still pending, let me know. I'll be right back.
Well, I can't bloop, and I think he did all the blooping that we could do. So let's see what you guys are saying over here. Thanks, Bluetooth. Love you, Bob and Allie and family. Here for the trial all over again with you. Can't think of a better place than this channel. Well, thanks, Bluetooth, and thanks for your generosity. Jim, thanks for your generosity, gifting a membership. Aspiring reporter. Bob, YouTube notifications don't seem to be working, FYI. Hopefully he saw that. Thank you for your generosity and your modding. Pokemom, member for 15 months. Show the like button some love. Well, thanks for your generosity being a member for 15 months. And Pammy for being a member for 14 months. And Cat Growl for being a member for 4 months. We appreciate it, you guys. We really do. Kalos says, am I the only one yelling? It's in the report. How does she not know this? Thanks for your generosity. And yeah, Close is talking about the judge still not understanding what the which ARCA witness did what. Did they ever tell us? Well, yeah, Judge, I remember, you had that initial concern, but then we did this whole voir dire thing and we did this whole trial thing. And, that was all pretty much fleshed out there. Jim, thanks for your generosity. Is the ARCA info he's asking for considered exculpatory or whatever else it may be called to the Commonwealth, or just Hank being a pain in the ass? So it's mostly just Hank being a pain in the ass. Some of what he asked for is discoverable. So that's what it would be considered when it's the Commonwealth asking for it, that it's that they're entitled to it under the discovery rules. So anything that an expert, relied on, things like that. But then some of the stuff he knows damn well that they said, like saying that, well, they said the emails aren't in their possession. We kind of went over that before. Well, clearly, if they sent an email, it would be in their possession. So no, Hank, that's not what they're saying. So most of it was Hank just being a pain in the ass. Chicagoland says, free Karen Reed. Thanks for your generosity. I couldn't hear you because I was talking. Thank you, Bob. I'll be using that later. Love your show. Neighbors. He's in Elk Grove Village. Nice. Yeah. Well, he was talking, but I wanted to talk over him. Darlene, thanks for your generosity. Could his counsel argue he took the fit? Oh, Bob just discussed that. And yes, that is what he's arguing. And again, adding to that, what I sort of said about the argument that it's not even because he thinks he committed a crime. It's because the prosecution is misinterpreting the statute. And because of that, his statements about otherwise innocent behavior do actually put him in jeopardy, because they are actually moving to convict him for that conduct, which they're arguing is not criminal and is only based on the prosecution or the Commonwealth's misconception about the statute that he's being charged under. Alessi never sleeps. Thanks for your generosity as well. I hear somebody must have showed up because I hear Bob up there talking to somebody. Leslie Never Sleeps is also in the Western Burbs too. Nice. Well, for all of you guys out there in the Chicagoland area, I don't know if Bob already told you, but we had a great weekend of music and fun. There is a new venue in Chicago called Garcia's. The people who who own that and who put that together are like seriously well-established music people. They know what is good. They've put together a ton of stuff. It's all things that your average music goer won't necessarily have heard of, but if you go, I can assure you your socks will get blown off. We saw Eric Krasno and Stanton Moore. Eric Krasno is an amazing drummer. He was the drummer in the band Lettuce, if you've heard of that band. Stanton Moore is an amazing drummer. He is the drummer in Galactic, and they are doing the Krasno Moore project. So that was sick. And they've got a lot of great things coming up. And soon they will have the Nth Power. I don't really know exactly when that is. The Nth Power are close friends of ours.
You are unmuted.
Court is back in session. You may be seated.
All right, Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
Judge, I would suggest that the court could take judicial notice of the 16
Yep.
indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
He
you-
doesn't have to assert it.
to make the representation on behalf of Mr. Carney that he would in fact invoke his
Didn't
Fifth
even
Amendment
have to.
privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Mr. Kearney to consider his fifth.
Oh, I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradel.
Thank
And
you.
all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
Kearney's like, oh. Or Carney's like, I wanted to get on the stand
You
and do
did
it.
it. You said Kearney.
I'll always do it because that's how it's spelled. I'm a phonetic guy. I spell
Well,
it like
That's
I'll
rude.
always call.
It's rude, sir.
You know what's rude is them pronouncing it Carney when it's spelled Kearney. Just like I'll always call Reading Railroad Reading Railroad.
I
'cause
know
it's
you've
spelled-
told us. Well, but you could call Reed Red.
Yes, true. I read a book. Past tensing. I don't know. So what happened?
The Commonwealth conceded he has a Fifth Amendment privilege, and then the attorney asked.
Conceded? What?
She asked him, "Are you a?"
Tori.
Yes.
So she was taking his assertion off as a sidebar.
All right, so Mr. Brennan, I've just had a colloquy with Mr. Carney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege.
So he's not a
And
witness.
I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except
standing.
as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the two
No.
minors in that list.
Oh, yes, I think I did that last time as well.
Thank you
Oh,
very
okay,
much, Your
you
Honor.
did?
All
Okay.
right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any
Oh,
further commentary
sure.
on it, just in case there's any further action, which I don't anticipate right now,
Okay,
but just for the record, thank you.
okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them.
So all of that just shows that Brennan did
Do you-
all of that.
all
for
right,
show.
this looks like you all made some progress
What the aid and
Listen-
shit?
Yeah.
in a way that where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue,
Oh, okay.
if the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy and
And it is something that we've done.
right, understood. I would like to see what I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, so the court, please.
We'll just wait a minute to see if we get a hot mic moment. Nope. They shut it down. So yeah, Brennan knew damn well and acknowledged on the record that he was acknowledging and understood that that Carney had a Fifth Amendment right, that he was within his rights to invoke his Fifth Amendment privilege in this scenario, that the information at issue would encroach on his Fifth Amendment right. So yes, Your Honor, I named him as a witness to try to keep him out of the courtroom, and I thought maybe it was going to work.
Right. Yeah, I mean, it was definitely all for show. There's no question about that. All right, y'all, we love you. Our Valo coverage starts at 1:30. Allie and I are going to take the opportunity to eat. We suggest you all do that as well, whether it be lunch or dinner. Thank you for hanging with us. Thank you all for your generosity, as we always appreciate that. And thank you, mods. We love you. All right, y'all. So 1:30 Central Standard Time for Valo. And remember, tonight I've got practice, so I'm gonna dip on Valo late. Actually, I think they're only going to 4:30. I think I might be okay today, but we are gonna do our members only voicemail extraordinaire questions, where we're gonna play the voicemails. If you go to our community page and you want to leave a voicemail, it's not too late. Do it. You're gonna get to hear your own voice on the pod.
And if any of our podcast patrons are listening, you guys will get a link.
Yeah.
So hopefully you've done that, or do it now.
I haven't done it yet. I haven't created a live yet. So
Oof. Well, at least let them know then. Put a link will be coming.
I mean, if you join Patreon through like YouTube, because they're connected, they're hearing it.
Yeah. All right.
I mean, I have to put the link in Patreon anyway. So
I know, but I'm saying give them a heads up. We'll talk about it off air.
Okay. All right. And somebody else can do it from our team. That sounds like a somebody else job. I'm kidding. I'll do it. I love doing all of that stuff. It's all the inner workings. All right, y'all. We'll see you guys at 1:30, because without y'all, I'm just an old man.
Talking a lot of shit.
Talking all the